I do, Brad.
Tracy?
Oh,
Okay.
go ahead, Tracy.
I had a question last week with regards to the timing of the grand jury and how that works.
Okay.
And my question pertained to how long it takes to get back the drug results. Like if somebody gets arrested for having a white powder, you guys need to know if it was really talcum powder or something else. And is there like a delay getting that back that delays the whole grand jury, going to grand jury process?
That is actually a very good question. We do have a problem right now with our labs being inundated, BCI labs with drug report requests around the state. You figure what we have in Summit County, there are 87 other counties doing that. Right now, we are still doing on field tests and that ones that we believe. However, we have to do some other testing. So there are cases that are being indicted without reports completed. There are times where if there's a time delay on a case, we will talk to BCI and they are cooperative with us in trying to expedite some of those. But a lot of those cases, people are out on bond, so we have plenty of time to get those reports out.
And I also know that I think one of our topics later on in the Citizens Academy is going to talk about drug cases specifically. So we'll address that as well.
Right. I just, since we were getting such a nice timeline with regards to how things happen, my question really kind of pertained more to that than just drugs in general. So thank you for the explanation of that. I appreciate it.
Yep, we do have monkey wrenches in the system.
But we try to, we do our best to make sure that, there are thorough investigations done. Speaking of thorough investigations and speaking of prosecutor ethics, Brad Gessner is here. Brad, we're going to get started. I think it's about 6:05 now, 6:04. We've got plenty of people, I think, have joined us. The majority of our class have joined us. So Brad is our chief counsel. He is, I guess you could say, second in command behind Summit County Prosecutor Sherry Bevan Walsh. And Brad, if you want to do your own little introduction quick, and then we'll get into your presentation.
Sure. I started as a legal intern in the Canton City Prosecutor's Office in 1984. So I just look very young for my age. So I've worked all but 10 years of my career as a prosecutor, all but 5 years of my career as a prosecutor. I left after 10 years and did civil work for 5 years. And then when I met Prosecutor Walsh, I decided it was time to come back to prosecuting because I agreed with her philosophies on how we conduct ourselves as prosecutors and how we handle ourselves with our cases. And that actually leads us into prosecutor ethics. James, you can move to the next slide. You hear a lot about unethical issues relating to prosecutors. And what you're going to find out tonight is there are rules that apply to only us prosecutors. They don't apply to defense attorneys. They don't apply to civil attorneys. There are specific rules that go over and above what any other attorney in the legal system has. But that's right, a good reason, because we are the only attorneys in the entire legal system who have an obligation to see that the truth prevails. A defense attorney, they can do whatever they want to try to question that, to confuse people. That's actually part of their job. Civil attorneys, they are to zealously represent their clients. We, on the other hand, prosecutors, it's our job to represent the ideals and the beliefs of justice. So the ABA has specific rules. They have rules that apply to all attorneys, but specific ones just for prosecutors. And understanding that prosecutors and defense attorneys, we butt heads a lot. So again, they look at these different things. James, on to the next slide. Again, in these rules, they call for greater collaboration and civility for us, which they say will lead to a fairer and more efficient criminal justice system. And you'll hear as we go through this in Criminal Rule 16, our discovery. We don't have trials by ambush in the state of Ohio. And further, in the Summit County Prosecutor's Office, we've been ahead of the curve. So several years ago, when Thomas Moyer was Chief Justice of the Ohio Supreme Court, they amended the rules for discovery to say prosecutors have to give everything to the defense. The defense is supposed to give everything to the prosecutors. I can tell you judges really only enforce the prosecutors giving it to the defense. So when we pull up a witness in court or a document or a report or an analysis of something, a photo even, that defense attorney has had copies of that for sufficient time to prepare and be ready for trial before any jury is ever even impaneled. And I always had a hard time because the courts don't force the defense to be reciprocal. I'm saying if the idea is fairness and justice, where's this at? Well, the Supreme Court of the United States in 1967 decided this case, United States versus Billy Joe Wade. And in it, Justice Byron Whizzer White ruled that prosecutors have the, James, go back. My bifocals aren't working good, so I can't see my little paper in front of me. Prosecutors have the obligation to convict the guilty and to make sure we don't convict the innocent. Okay, now you can go forward. Okay, and defense counsel has no comparable obligation to present or ascertain the truth. And so that's how our system should be. Again, we are trying to convict someone that could deprive them of their liberty. So we have to be able to prove our case, and it should be open to attacks that are fair and unfair, because the truth should be able to withstand any type of attack. And that's what the Supreme Court set out. So now the job of a prosecutor is to get to the truth. Okay, next slide, James. Okay, the ABA rules of professional conduct. Rule 3.8A, we refrain from prosecuting a charge that is not supported by probable cause. The national prosecution standards out of the National District Attorneys Association. These aren't binding on us, but we follow them. Section 43.1, charges filed should encompass the offense believed to be committed. So what the evidence supports, not what we'd really like to do, but what we really think we can prove. Only 43.3, only charges that are reasonably substantiated by admissible evidence. There's some hiccups in my PowerPoint that weren't there before, so I don't know what's going on there, but we'll move on to the next one. So we've got the ABA, we've got the National District Attorneys Association, and then we have the Ohio Supreme Court in the Ohio Rules of Professional Conduct. Again, while they're rules that apply to all attorneys, there's a special section 3.8 that only applies to prosecutors. We have a responsibility of a minister of justice and not simply that of an advocate. So we're not just fighting for one side or the other, we're fighting for justice. Next. I have the best single case example of the responsibilities of an American prosecutor. Go ahead, James. Brady versus Maryland. Okay, so you'll hear, and in the criminal justice system, you hear someone's entitled to what's called Brady information. Brady information is anything that might exonerate or show someone didn't commit an offense. So the most important thing, while we can give evidence of someone's guilt, if there are reasons or questions we have in there, those are even more important to give. So we have 10 people who see something and 9 people identify the defendant, and one person says that wasn't him. We are required to give all 10 of those statements to the defense attorney, not just the 9 that help us, but even the one that says this isn't the person. So Brady versus Maryland was a 1963 case. It was a landmark case in the Supreme Court. It's still in effect today, and still, I mean, any criminal defense attorney, any prosecutor, you say, tell me about Brady versus Maryland. If they can't tell you about it, they shouldn't be practicing law. So again, any exculpatory evidence or anything that helps exonerate is required to be turned over. And this goes back to 1963. So almost as old as me is how far this goes back. But while it was a landmark case, it just started out as this ordinary little case, and we're going to talk about it quickly because I think it's interesting. So we'll start off by who the characters were. Who was Brady? What did Brady do? I'll tell you who Brady was. James, you're moving too fast on me. Okay, Brady was a young guy who had grown up. He was bounced from family member to family member. He ended up being raised by his grandmother. He had some type of ear disease when he was young that caused him to ooze in school and that. So no one liked Brady. No one got along with him. People made fun of him. He was bullied for years. And finally, he grew up and joined the military. And when he went off to the military, everything changed in his life. Everything got better. And when he got out, he came out and he met this woman, and she was just the most beautiful person he thought he'd ever seen. So he fell in love with her. There was only one problem. She was already married. So Brady decided that he would profess his love for her and woo her away from her husband. Her brother was one of his best friends. So now we know who Brady was. On to the next slide, James. What did Brady do? Well, to show his love for her when he didn't have really two nickels to rub together, he told her that he loved her so much, and also along the way, she ended up getting pregnant to him. So she told him, this is, if you really love me, you've got to show me how you love me. So Brady showed her on the next slide. He gave her a check. He gave Nancy a check for $35,000 and said, I want you to hold this check and don't cash it for a week, because in a week, I'm going to give you this money to just so you know how much I love you. And remember that part I said about Brady didn't have two nickels to rub together? He still didn't when he wrote the check. So Brady decided, and this is back in 1958, that he had to come up with a plan. So he talked to his friend, Nancy, Boblett's brother, and said, can you help me here? So they said, you know what? If we go rob a bank, we can get the money. And he said, okay, but if we go rob a bank, we've got to have reliable transportation to be able to get away, or we're going to get caught. So Brady said, you know what? I know this man who's been a family friend for years. He just lives down the lane. He's all by himself, and he got a brand new car. I think it was a Buick, and it was really nice. And what we can do is we can pretend like we're robbing him. We'll wear masks. We'll steal his car. We'll go commit the robbery, and then we'll bring his car back to him. And Boblett said, that sounds good to me. We'll do that. So they put a tree down in the road, and when they stopped him, he got out. Well, they forgot the masks. And so when Brady went into the woods to get something, they wanted to knock him out, Boblett decided, we just got to kill the guy. And that's what happened. Next slide, James. Okay, so again, they tie him up, they put twigs, they cover him over with shrubs, and they leave him there, and they take off. Well, they got so worried and nervous about this that they forgot to go rob the bank. So they decided they were going to just hightail it from Maryland, that they went to Washington, and they were going to go to somewhere out west. And they decided then, once they got going, that Boblett decided he didn't really want to be home, away from home that long. So he went back home, and Brady took off. So Brady, when he was in the military, he had met some guys who became mercenaries in Cuba. And he decided, this is what I'm going to do. I'm going to go become a mercenary in Cuba. So Brady took off. James, the next slide. And he went down to Cuba. And while he was in Cuba, they found the body. When they found the body, they went to Boblett. When they went to Boblett, he confessed and said, I had nothing to do with this. This was all Brady and his idea. So once he got down to Cuba, he started to miss his Nancy, his girlfriend, and he sent her a letter and said, I'll come home and make this good. But what he didn't know is Nancy then went to the bank to cash the check. And when the bank teller started laughing at her, telling her there's not a penny in the account, she became very angry with Brady. So Brady knew he had to get home and make things right with Nancy and be there for when his child was born. So he decided he would go back to the United States, and he then went and turned himself in. He went to the consulate, and they said, we're going to fly you over to Miami, and they'll take you back home from there. And he said, yeah, I just want to let you know, I just robbed this guy, and that's all I did. I mean, I stole his car, and I had nothing else to do with this. So let's go back to the next slide. Okay, so when he got to Miami, the FBI was waiting for him. They handcuffed him and they let him know he was being charged with murder and that he could get the death penalty in Maryland. And he said, but I'm not the one who did anything. And he said, Boblet did it. And they said, but you already told us you did it. You told us you committed the robbery. So on to the next slide. They end up charging two of them with murder. And as they're waiting for trial, Boblet wants to get a plea deal. Boblet, who's the actual killer in the case. So now Boblet, what you need to know is he gave the police the first interview where he said Brady did it all. He gave the second interview where he said Brady did it all. He gave a third interview that he said Brady did it all. And he gave a fourth interview where he said, let me tell you the truth, I did it, Brady didn't, and he actually was trying to stop me. So the prosecutors at the time decide, let's give the defense attorneys the evidence, and they give them 1, 2, 3 statements. They withhold that fourth statement. So on to the next slide. We see them being arraigned. On to the next slide. Okay, next slide. We already talked about that. 1 statement they gave, 2 statements they gave, 3 statements they gave, 4 statements they didn't give. Okay, on to the next slide. Actually 4, and I'm sorry, the 5th statement they didn't give. I'm sorry. On to the next slide, James. Okay, so believe it or not, then Brady went to trial and Brady was convicted. The jury came back and decided Brady should be executed. Shortly after that, Boblet pled guilty. An attorney came in, and just so you know, Boblet testified at Brady's trial, and he went with the first 4 statements that said Brady did it all. Basically, I tried to stop him. So prosecutors didn't know anything else. Well, a priest came to visit Brady in prison. Brady talked to him, explained everything, and he decided he felt there was something more there than was to the eye in the case. So he ended up connecting Brady to a lawyer to do the appeal. Next slide, James. Okay, and they went through, and the attorney's looking through everything, and he starts reading these notes, and he realizes that at some point, Boblet made a statement of, well, that's not what I told him the last time I talked. And the attorney went through and said, well, I have all 4 statements that you made, and they're all the same. And if the last one wasn't the same as the one before, my 4th statement is the same as the 3rd and the 2nd and the 1st. So he started to get suspicious, and he said, let's go through this. And it found out ultimately that there was that 5th statement that had been withheld. So go on, James. So he took it to the Maryland Court of Appeals, and they affirmed the conviction. He then took it to the US Supreme Court. Again, back in the early 1960s, he did that. So at the Supreme Court, this information came up, and go ahead, James. Justice William O. Douglas, who was one of the longest serving justices at the time, wrote the decision. It was 7-2. So Supreme Court decisions don't have to be unanimous. Douglas was the majority writer, and he said, if a state has contrived a conviction through the pretense of a trial which truth is but used as a means of depriving a defendant of liberty through a deliberate deception, such contrivance by a state to procure the conviction and imprisonment on a defendant is the obtaining of a like result by intimidation. And so basically, Justice Douglas did what is our Brady thing now. If it's exculpatory, you give it. This is about truth. Again, our first issue right there in the beginning where he said our job is about truth. That's what Justice Douglas said. Now go on, James. So, but the Supreme Court now, you think, okay, the Supreme Court ruled in Brady's favor. So what did they do? They then affirmed his conviction. And they said, but we believe that there was overwhelming evidence against Brady. And again, irrespective of the good or bad faith of the prosecutor, we don't think it really affected the outcome because he was he was he was complicit. He was a co-conspirator here. So he's equally as guilty. So they made law, but they didn't do anything at that point to help Brady. On to the next slide. The question remains whether petitioner was denied constitutional rights when the Court of Appeals restricted his new trial. The present case, unanimous Court of Appeals has said nothing in the suppressed confession could have reduced the appellant Brady's offense below murder of the first degree. So what they did, though, is they set it back to the Court of Appeals to say, look at this, apply this law and see what needs to be done. Does he decide, should he have a new trial? We cannot raise trial strategy to the dignity of a constitutional right, saying deprival of a sporting chance denies him due process or violates equal protection. Well, I can tell you the majority of attorneys and judges in the United States consider Brady to be failure to give Brady information to be a violation of due process today. So what Justice Douglas started has advanced and expanded over the years. On to the next one, James. Okay, there was a dissent by Justice Harlan and Justice Black, who said, again, this was so bad that he should have had his case reversed. Next slide. Okay, so pursuant to Brady versus Maryland and its progeny, the government has a continuing obligation to produce all evidence required by the law and the federal rules of criminal procedure. That's the case you can see today, where again, it says Brady is actually more than it really was at the time of the decision of Justice Douglas. Next, James. So in the end, what happened to Brady? So they're back in Maryland and they're trying to decide what goes on with this. Well, politics got involved. Everyone was afraid. How do we try the case? And everyone basically sat on their hands until after 18 years in prison, Maryland just paroled Brady. He ended up leaving prison. He went to live in Florida. He got married again. He had children. He lived a productive life, never had as much as a traffic ticket the rest of his life. Okay, so what happened to his co-defendant, Boblett? Donald Boblett got out of prison. He got paroled and immediately committed a violent rape and went back to prison and died in prison. Next slide. And this was a letter that Brady had written to just in his own journal. For 6 lonely years, this is before the appeal, I have watched the great stars, searched and wondered if I would be alive to watch them another day. I have died 1,000 deaths during the past year. Each day I died a little more. I look out upon the world and see only darkness. I am alone, without love, without friends, without hope. My only companion is fear. That is while Brady was on death row for a crime that he didn't intend to commit, but he did participate in. So next slide. Okay. So when it comes to prosecutors and we have to decide, do we give something or not? This isn't how you determine it. This slide here. Okay. It's not, well, there's a good reason to give it. There's a good reason to keep it away. It's you give it. Go ahead, James. There are 110,000 plus cases in the United States in legal research that cite the Brady case. There are 39,315 cases that have been, the decisions have been clearly based on Brady. There are 5,000 secondary sources, law reviews, other things that explain Brady to us. In Ohio, there have been 981 Ohio court cases that have Brady issues that come up in them. So this is, again, going back to 1963, one of the most important cases we could have. So we're going to skip through this. This is just a couple other examples. Skip that one, James. Okay, so I just wanted to leave you for a couple minutes of any questions or that. Like I said, when it comes down to it, we have to give information that might hurt our case. I mean, we have someone there on video, they're caught red-handed, but there's a witness that says they weren't there. That's not the guy. We turn that over. So we try our cases, we like to say, warts and all. Because again, if the truth is there, it's going to withstand attacks fair and unfair, if you go all the way back to Billy Joe Wade. Again, that's our job. We don't ever want to convict someone who is innocent. That's the worst thing you could ever do in a career as a prosecutor. So again, there are times where we exercise our judgment in not charging individuals. There are times where we take a case to grand jury and the grand jury no bills it. So they've gone through. There are cases that as we prepare for trial, we realize there are problems with them and we dismiss those cases. You'll see though that 96% of our cases in our office are results in convictions. The majority of those with people entering pleas of guilty. So that shows we're working really hard on the cases we indict to make sure those are the good cases and those are the cases that we believe we can prove. If I don't believe in a case as a prosecutor, I'm not going to try it. And Prosecutor Walsh is clear on that to all of us. We have to believe the evidence in our case or we're not going to go forward. So you hear a lot of things about prosecutors out there. You've heard a lot of mistakes of prosecutors throughout the country, but we've owned up to any mistakes we've made. We actually created a conviction review unit. We're one of the few prosecutors' offices in the state where after you've exhausted all your appeals and all your rights to legally challenge your case, we've agreed if there's a good faith basis for it, we'll look into that case again and police ourselves. So I'm very proud of the work all of our prosecutors do in the office. I'm proud of our ethical standards, and I hope that they're as high as you would hope we all would have them. So, I mean, that's something we take great pride in. Again, working to get that conviction because it's right, not just because it's something that you do. So, any questions?
I have a question.
Go ahead.
So I was on a trial many years ago, and it was a murder trial. And we actually were kind of, we weren't allowed to know the gentleman's prior issues with the law. So, however, we just weren't allowed to know that. Why is that?
Okay, because those prior convictions might taint you as a juror, and you're going to say, if the person did this previously or did all of those things, they're a bad person, and now you're going to judge them on the character you believe about them rather than the facts and the elements that we're required to prove. That's why I'm starting out as an attorney. I don't get in a courtroom to try many cases. Now, more of an administrator in the office. We'd always start out, back when I started, we used a chalkboard in courtrooms, and we would write the elements of our case there and check them off in closing arguments. I mean, one of the elements was that the crime occurred in Summit County. If we didn't prove it occurred in Summit County, the case was done. If we didn't prove the identity that this was the individual, the case was done. So courts at different times will allow some convictions in. They will at other times not allow convictions in. My guess is that your defendant didn't testify in your trial, right?
No, he did not.
See, and that's why a lot of defendants don't testify, because the rules say if someone does testify and they have those bad things in their past, the jurors can consider that, because that will go to their credibility or truthfulness. And there it's a fine line then that we're using those convictions to attack their credibility and truthfulness, but not to prove our case. Now there's one exception. There's criminal rule 404B, which says if someone commits crimes in a certain pattern or method, and that, like, this is their calling card, we can at times bring in some of those prior acts, again, to show this wasn't a mistake. This is how they've done in the past. That help?
Yes, thank you.
All right.
That sounds like the implicit bias we learned in the first meeting we had. You know, it will taint you.
Yeah.
Yeah.
Yes.
But I had a question. I thought it was very interesting that prosecutor ethics, you have specific rules above and beyond. I guess my question would be, is it consistent from state to state? Is this, these are national prosecutor ethics? Go ahead.
No, it is not. The ABA has their rules, which Ohio patterns similarly to. The National District Attorneys have, again, those are recommendations for us, and we choose to follow them. But each state and Supreme Court can make their own rules there. But as far as Brady, that's going to be across the country. Okay. So any other questions? If not, we're eating into Angie's time, and Angie gets mad at me when I take her time.
Brad,
All right.
There's a lot of information you went through. I'm sorry, I didn't mean to cut you off, Brad. Go ahead.
So our next prosecutor is Angela Walls Alexander. She is one of our domestic violence prosecutors. She probably has more experience than anyone in Summit County in handling domestic violence cases. And so, James, unless you want to do any additional introduction, Angela, you can take over, and I'm going to take off. It was nice to meet all of you, and see you down the road.
Thanks, Brad. Also, before you get started, if anybody has any additional questions for Brad, you can just pop them in the chat. I can see if I can kind of answer them. Maybe Angie can answer them, or we'll be able to answer them maybe next week if I'll be able to ask Brad those questions. But thanks again. That was a lot of information in a very short amount of time. Brad went through it pretty quick. So Angie, I don't want to take up any more time. I'm going to share the screen and share your presentation, and we'll get going.
Right, great.
So whenever you want to start.
Uh-oh. Are you going to hit?
I am. I have to, unfortunately with
Okay.
Zoom, I have to wait for the computer to catch up.
Okay,
with me.
well, I can just start with my introduction while James is working on that. My name is Angela Walls Alexander, and I've been a domestic violence prosecutor for about 16 years now. Before I was a prosecutor, I was a public defender doing criminal defense and private practice for 6 years. So I've had some time on both sides of the criminal justice system, and it's given me, I think, a unique perspective on the criminal justice system, and understanding that, what I do as a prosecutor is very important, and having experienced defense attorney on the other side is a good thing to challenge us to make sure that we're meeting our burden of proof beyond reasonable doubt. What I can tell you about training in domestic violence is I've had countless trainings on how to prosecute domestic violence, how to work with victims who have various issues from mental health to substance abuse, and as well as working with offenders to try and rehabilitate and break the cycle as it relates to domestic violence. And I am very proud of the progress that Prosecutor Walsh has made in the area of domestic violence. What I can tell you is I've been at least in one other county, and their prosecution of domestic violence is nothing like what Prosecutor Walsh has, as far as keeping victims safe, holding offenders accountable, and making sure that people get the treatment and help they need if they want that treatment and help. So you're very lucky to have this type of a program and service in Summit County. So just a little bit about domestic violence, and I'd like to stop at the end of each slide and ask if you have any questions about the slide. And for domestic violence, it's more of a conversation, because I know not everyone has their camera on, but most of us throughout our life have had some contact with someone who's been a victim of domestic violence. And that could be anywhere from physical violence to emotional abuse, psychological abuse, child abuse as a form of domestic violence. So most people have at least some familiarity with the idea of family or intimate partner violence. So go ahead with the first slide, James. So under the Ohio Revised Code, it specifically describes what domestic violence is as far as a crime, and the requirements that we have to prove for domestic violence are that they are family or household members living together, intimate partners living together, parent-child, or living as a spouse, husband and wife, or partners. And what I can tell you about the relationships and why domestic violence is specifically labeled out and different from assault. Assault is if you would cause or attempt to cause physical harm to a stranger, or if, a bar fight, someone you don't know, or even a friend, that would be assault. Domestic violence is specifically codified based on the relationship with the offender and the victim. Next slide. So what I can tell you about how we prosecute domestic violence in Summit County is we use the evidence-based approach. And what that means is that we take a case, and the way that I like to describe it is every time I get a new domestic violence case file, I immediately look at that case as though the victim is not there. So I kind of draw an analogy between a murder case and a DV case. And I may say DV, that's domestic violence, is our abbreviation for domestic violence, but I will look at it as though it's a murder case. So let's say the victim is not in the picture, that they've been murdered by some person. And I look at the evidence. Uh-oh. I got to echo. Let me see. I think somebody's muted. Okay. I look at the evidence of the crime. So what I would do as far as, uh-oh, something's in the middle of the screen. You there, James?
Yep, that was me. I'm sorry. I needed to check
Okay.
something. I apologize.
That's okay. So what I do is I look at all the evidence. So the physical evidence, and I'll go through all of kind of the pieces of evidence that put this together, but I remove the victim from the equation. And the reason I do that is because we know, based on research and years of doing these. Uh-oh. James,
Yeah, what's up?
something's wrong here.
I don't know. I hope everybody can see the thing. I don't think anything's.
Oh, I'm sorry. Hold on.
No, that's
one second.
okay. That's all right.
No, for some reason. Okay, for some reason it popped up as just.
I stopped sharing, but
Okay,
we can
I see.
start. Your
Yeah.
audio was a little off, but I think we're okay.
You know what? I can put headphones on. Let me put
Okay,
some
we'll take a moment. It's fine. I think hopefully everybody's kind of used to, unfortunately, these situations when it comes to video conferencing. So it'll be okay. I was having, for whatever reason, my laptop is being a little goofy too. So
I'm on the work laptop and I usually use my iPad, but I thought then that way I can see everyone, but it's
yeah, my work laptop doesn't want to play nice, so we'll be able to make it through. Just let me know whenever you're ready. You may have to just check your audio just to make sure we can hear you. Nope.
Can you hear me?
Oh, wait.
Can you hear
Start
me
talking
now?
in. I can hear you. I hope everybody else can hear, Angie.
Is that better?
I got thumbs up from a couple of people.
Thumbs
that's
up.
much better.
Okay.
Much better. All right.
All right. So I look at it as a murder case, and I look at the case without the victim, because what we know is that there are times when a victim would not want to pursue a domestic violence case. And sometimes you might think, well, if the victim doesn't want to prosecute, then
drop the case, or, if they don't want to go forward, then why are you going forward? And what we know based on the research is that it's very hard for victims to, especially people who've been in intimate partner relationships, to come forward, to prosecute, to come to court, to testify against a loved one. So I like to remove the victim from that part of the case initially, so that I can get a good look of what the evidence is. So part of looking at, your victim and what drives their conduct. I want to go ahead to the next slide, James. I'm going to talk to you just real quickly about the power and control wheel. And that's something that I want jurors to know about in my trials, and I want you all to know about, because it's very important that we all understand why someone might come in and say lie for their loved one or refuse to come to court. It all kind of centers around the power and control wheel, as well as the cycle of violence. And what this is it describes some of the reasons why victims may remain with their abuser and or not want to cooperate with prosecution. So the first piece is the use of intimidation. And what we know is that there are times where an offender may threaten to kill the victim if they prosecute, or they may have a more subtle threat. I'm going to, take the kids and move out of the country, or I'm going to destroy everything that you own, or I'm going to make you lose your job if you do this. So there are other ways of intimidation other than that kind of direct threat to kill. The next piece would be the emotional abuse aspect. And what I like to say about this is just, putting the other person down, calling them names, making them feel bad about themselves, making them believe that the offender is the only person who would ever love them. And this works really, really well. What I can say is I've probably dealt with well over 1,000 victims, and this is used 90% of the time, because what happens is that as they continue to stay in this relationship, they really believe that. Because another part that comes in the abusive relationship is the isolation. So at some point during the relationship, sometimes, and these aren't all every relationship every time, but sometimes offenders will use isolation. So they will not have any friends or family. They will not have any outside contact with other people to socialize. So they may truly believe that this is the only person that will love them, and that their family, they may be convinced that their family turned their back on them, the offender. And so it's a really effective piece of manipulation within this wheel. Minimizing, denying, or blaming. This is huge as well. I see a lot where victims will come in and say, if I would have just left the house that day, or if I would have just not argued with them that day, or, this is all my fault, I wasn't taking my mental health meds. So kind of that denying and self-blame, it's really, I see it a lot. And the minimizing, this isn't that bad, I didn't have to stay in the hospital this time, or it's just, I was just choked a little. So I see that as well. And then using the kids, I'm not going to see the kids anymore if you prosecute. Just different types of using the children. Using male privilege. I'm the husband. I'm the man in the relationship, and that is a little. That's kind of less. I see that less frequently than the others, but that's definitely still a piece. Economic abuse. It can be financial, where you have an abuser who is refusing to give the victim money, or trying to evict them if they prosecute. And also, as part of this, you could have, I see a lot now where the offender may be the babysitter for the victim, and so they may refuse to babysit the kids so that the person can go to work. and then use of coercion and threats, which is kind of self-explanatory. And as I go throughout my presentation, I always like to clarify, I fall into the pattern of saying she is the victim and he is the offender, only because that's about 90% of, well, I would say 80 now, 80% of the cases that I deal with are female victims, male offender. But what we're seeing, and I've seen probably in the last 3 or 4 years, is an increase in male victims and female defendants. And I attribute that to men are being, I think men have always been victims, but it's kind of the male, that I'm the man and she's the woman and I'm not going to report it. I should be able to, protect myself. So I think men have always been victims of domestic violence. I just think now that it's more socially acceptable for them to come forward. And a lot of men are now realizing that if they don't report it and they have to defend themselves, they could get charged. So they are more willing to, call the police to avoid a situation or report it. So I do see a little bit of an increase in our male victims, but I fall into that pattern of she or female victim just because that's the majority of what I deal with. But one thing I do try and do as part of my job is make sure that it's fair and that I'm treating my male victims equally to my female victims. Next slide. It's going to be a cycle of abuse, and this just describes how this happens. For a lot of people who are not or who have never been in an abusive relationship, it's easy to understand by looking at it this way. So what happens is you have a tension building phase. So let's say there's an argument and they start screaming, and the next thing you know, there's either physical, emotional, or abuse that happens. And at that point, there may be, criminal charges, there may not, but at some point after that, there comes a reconciliation phase, or what used to be referred to as the honeymoon phase. And this is where the abuser apologizes, blames the victim, denies, and kind of all those power and control aspects can come into play. And then everything's good, everything's calm, and back to the relationship they go. And sometimes people can go through this cycle 3 or 4 times in a day. So it's definitely a pattern in an unhealthy abusive relationship. Next slide. So one piece that I like to use as far as evaluating a case is a lethal assessment. And the reason we use these is because we know that domestic violence crimes can escalate quickly into a lethal situation. So I like to use these for determining bond and whether out into the community. I also like to use them for sentencing and then treatment as well. It gives you an idea of how to best assist the family. One thing that I've learned in all my years of doing this is that there's a good chance that even if someone goes to prison after a violent incident, they may end up back together. So in addition to punishment, I want to look at trying to get the offender the tools they need to stop that cycle, not necessarily just remove them from the situation. Next slide. And this is what a lethality assessment looks like. So these are some of the questions that I might ask a victim if I interview them. And I personally like to meet with, and now we're using Zoom for victim meetings. And what I can tell you is I like to have face-to-face meetings with victims in my office where they can, feel comfortable and know that what they tell me is confidential. So when COVID happened, we had to shift to the virtual platform. And at first I thought, oh, I'm not gonna like this. It's so much more effective when I can look someone in the eye and have them right across from me. And if I have an advocate there with them to kind of, you know, rub their shoulder or console them if they cry. And I thought this is not going to work with, with COVID. And Kathy, I will answer your question as soon as I finish what I was going to say. So with COVID, we had to switch to online platform. And one thing that I was mindful of it, but I'm even more mindful of it now, is that a lot of victims, they have to work. So they had to take off work to come down to Summit County Prosecutor's Office, park a parking deck, pay for the parking fee, and then, or no, we actually validate now, but it used to be even pay a meter or pay for parking. They had to come sit, you know, in this intimidating office and then come talk to me and talk about the worst thing that happened to them. And if they had small children at home, they had to get childcare, or they had to bring the children in. And then the children were in there listening to these terrible things that happened to their mom or dad. So COVID, one upside to COVID, I think, is that we now have realized, or at least I've realized, I can use this platform and interview my victims, do my lethality assessment, get what I feel that I need for the case, and they can be in the comfort of their own house where they feel safe, or they can go out to their car for their 20-minute lunch break or break and talk to me about it. And then we can, you know, get that information, and it's really not as much of an inconvenience for them. So for me, I even though I was hesitant to accept it, it has really, I think, benefited a lot of the victims. So Kathy, you asked, how quickly is the victim seen and is the perpetrator held in jail until you determine lethality? What I can tell you is that Akron police are supposed to do a quick lethality. I'm not sure if the other law enforcement agencies do it, but Akron was at some point doing a quick lethality assessment, or supposed to. And what I can tell you is that's not really happening at this point. And we're hopeful that we can put together a training where we go back to them and say, look, you know, now that we have body cam, we know that you're not doing this, but here's, you know, a quick cheat sheet on a couple of the questions that you can ask so that we can get, you know, an idea for bond. What I can tell you is that some officers, if they know the perpetrator, or if there's like a serious injury, they will write on their police report, do not release, ask judge to set high bond, but not the formal lethal assessment tool that we use. So a person would be arrested on domestic violence. The case then, if it's a felony, and I'm going to talk real quickly about that. So first time you're charged with domestic violence, it's a misdemeanor. If you're charged with it, if you're convicted and you're charged again, it's then a felony. And then it goes up again to a higher level felony if you're charged with it again. And I've seen offenders with, probably the most I've seen is 10 prior convictions for domestic violence. So each time it's kind of like DUI, it goes up. So what would happen is they would be arrested, and for it to come to us, it would have to be a felony. So they would be initially arraigned at municipal court at the lower court level. And at that point, a bond may be set, and the municipal court judge would then determine what bond they think is appropriate. Now, I'm not sure what the judges are given at municipal court, but what I can tell you, when they come to us, and this would be after grand jury, after they're indicted, then they're arraigned at the common pleas court. When it comes to us in our office, we then would look at all of these factors in determining if we feel that that was an appropriate bond. So there are a lot of times where I'll look at a file and see that municipal court set a really low bond on someone who I feel, based on the lethality assessment, needs a higher bond. And so what I then have to do is ask the common pleas judge to increase the bond and to hold them in jail while the case is pending. Okay. is it Nisi? Is that how you pronounce it?
It's Nikki,
Okay, the
actually.
question, Nikki, okay. How are they able to be charged many times? Do they get jail time? Who protects the victim if they keep having so many multiple charges? So what I can tell you as far as penalty, this is unfortunate. So domestic violence used to, and this is going to be maybe 5 years ago, so about 5 years ago, a domestic violence felony 3, which is the highest level domestic violence you could have, you could get a maximum of 5 years in prison. And that was 5 years is a lot. So we were looking at, sending people away for a significant amount of time when they had that many convictions. What the legislature did in their infinite wisdom is they decided to make a felony 3 the maximum amount of prison time that you can get on a felony 3 domestic violence is now 3 years. So I've seen offenders with 8 prior felony domestic violence convictions get only 3 years in prison because that's the cap. So it's fortunate, but that's just the state of the law right now. And we try and use whatever creative process we can to, let's say if a officer charged domestic violence, a felony 3, and we know someone has a terrible record and they broke her nose. Well, we may then be able to charge them with a felonious assault, which carries 2 to 8 years based on that serious physical harm. So we are always mindful of criminal record, lethality, what is in the best interest of the victim's safety in the community, as well as, offender treatment. And that's a piece that we consider, like I said, just because I know that they may end up back together in some cases. So in some cases, treatment's appropriate. So next slide. So how do we do it? The way that I prosecute cases when my victim is unavailable, or maybe it's a safety issue for the victim, and I need to build the case without them because they're afraid, intimidation by the offender's family, what have you. I look at 911 call, and this is really one of the pieces of the case that gives me a snapshot into that moment. When you hear a 911 call, you are actually hearing the victim at the time that they're at the most fearful. And so that can kind of set the tone for the case. And then if I have to try this case to a jury, then I'm going to play that for the jury and let them know this is a snapshot into that moment when they felt they had to call for help. Photos, of course, are important. If the ambulance comes out, EMS comes out, they document not only what the victim says, but also any injuries. So that is a really important piece of evidence that I will submit to a jury. Medical records, if they're strangled, and because we know based upon all of the research that if a victim is strangled or what they commonly refer to as choked, that they need to seek medical treatment to make sure that there's no internal injury, because we know that there can be life-threatening injuries internally that officers may not observe. So you may have a victim who is fine on the outside, but may have internal bleeding in the throat or swelling in there. And so we want to get medical records, and that would go to a jury. Jail calls, I listen to hours and hours and hours of jail calls. And for me, it gives me an idea of who I'm dealing with as far as offender, and sometimes who I'm dealing with as far as victims, because what will happen is I have 2 sets of offender jail calls. One set where we're crying and apologizing, we're so sorry it happened. The other is put money in my books, get rid of this case, do whatever you have to do to get me out. I'm not playing. So those are kind of two sides of the jail calls. And that's evidence that I can use against them because they all know, they're told when they go into the jail that the jail calls are recorded. And then before they make any phone call, it says these calls are being monitored or recorded. But I listen to jail calls because I want to make sure that I have, that an idea of what's going on, and that's effective evidence. And the body camera evidence now is, it's a game changer. I can tell you the 911 is good. The photos are good. And I would meet with my officers before body cam and they would tell me what they saw and heard. But nothing compares to watching it unfold as the officer's there and being able to kind of gauge, how's the offender acting? How's the victim acting? How does the victim appear? How is the officer behave? Does the officer do their investigation properly? So that really has become an effective piece in domestic violence prosecution, because what I can also do when victims come in and they say, the officer threatened to take my kids if I didn't prosecute, I can then play that body camera for them and say, well, here's the body camera and the officer didn't say that. Now I understand why they might want to lie and try and protect the offender, but I do want to give them, let them know that I'm not falling for, the officers threatened me. So if that's not the case, so that is an effective piece as well. Next slide. Now, I want to talk a little bit because we did talk, I know there's the question about victim safety, and I, in doing this so long, and seeing, victims murdered and terrible, violence that's committed by loved ones against each other, I take victim safety very seriously. And there are a lot of times where I'm recommending prison and the victim doesn't want it. But I want to look at the case from a safety perspective, but also we now have a domestic violence treatment court. And that's what this is. So back before we had a domestic violence court, we had two options. You sent a person to prison or you put them on basic probation. And what basic probation was is basically they'd call in, they maybe come see the probation officer, may not have to drop a drug test, may have to get what they called back then anger management, and it was just minimum supervision. And so the best practices then became the idea of a more intensive, intimate partner focused batters intervention. And this was more focused towards intimate partner relationship, breaking down some of those power and control and thinking errors that some of the offenders had in addressing substance abuse and addressing mental health. So to try, and the goal was to try and prevent further family violence. So what the court does now is it's called the Summit County Domestic Violence Intervention Court. And I've been a part of this for a while. And it's Judge Kathy Michael as the presiding judge. And that sorry about that. As you can see, I have a cat who's decided that she wants to jump on the computer. So we address, all the issues that come with intimate partner violence. But to get into the program, they have to be screened. And so what we do is we screen out any of those offenders who, let's say the offender who has 8 prior convictions or the serious injury cases. So we screen them out and we only take those individuals who are admitting at this point that they are an abuser and that they are in need of some type of help, a mental health assessment of them, a substance abuse assessment of them, and it's a collaborative approach. So the team, what we call the domestic violence court team, consists of 2 psychiatrists and 2 probation officers, the judge, and myself, as well as 2 victim advocates. So we have that team approach to looking at these cases. So we all then decide, based on their screen, who we want to keep and who we don't. And then they go through 3 years of intensive supervision. And what I mean by intensive supervision, today is domestic violence court day. So what I can tell you is from 1 o'clock until about 4 o'clock, we have offenders checking in with all of us. So I'm there, the judge is there, the advocates are there, the probation officers are there. And so we're checking in with them every week. And we have males and females. And so we're able to talk about, how they did in batters intervention court or batters intervention class that week. How did they test positive for any substances that week? Are they working? How's their job going? How's childcare, child visitation? And we also then have our advocates reaching out to those victims saying, how are things going? Is this person leaving you alone? Have any concerns? Is there anything you want the judge to know? And so it's really a really good approach to trying to rehabilitate a very, very violent population. And I don't know what the statistics are now, but years ago when before Judge Michael came in, we were at like an 80% success rate. But I don't know what we're at now because we lost a number. So we're trying to get back up to 100 defendants. And before this, those 100 defendants would have just went to prison because they're so high risk that there's no way I would have trusted standard probation. So this diverts them from prison, puts them on, this intensive accountability, and allows us to try and work with them and address, their needs as well. And there was a question about interpreter. We do have access to interpreters, but to date, I do not believe we've had anyone who's needed that service. We have had some offenders because part of the batters intervention class involves homework. So they'll go to class, they'll go to their group, they'll talk about, let's say they talk about male privilege, and then they'll have a homework in their booklet that they have to do. And after they have their meeting, and we had some offenders who were unable to read. So we were able to figure out a way to help them through that process and make it so that that's not a barrier to their getting the treatment that they need. Next slide. And this just breaks down what happens. So we have, the pre-screen. Is this a case that may be eligible, not eligible? Then we do the full screen where we look at, where do they fall in the lethality and risk? And then we move into the programs and which track they would be best on. And track 1 would be for our most high risk offenders. That's the 3-year probation. Track 2 is for the less moderate risk, and that's a 2-year period of community control. Next slide. So the way that the cases are handled in the office, as I kind of went through a lot of this in some of the information, some of the terms are kind of specialized. Sherry, Prosecutor Walsh, believes that not everyone should be handling domestic violence cases because there are some people who may, for whatever reason, not want to deal with, uncooperative victims because it can be very frustrating and disheartening. And so it can burn out, prosecutors. And I've seen a lot of people whose hearts were in the right place, but it wasn't for them. And so they were better off doing a different type of case. So what we do is part of the unit to kind of strengthen our unit is that we get special training on, how to prosecute how to deal with uncooperative victims. We have the specialty court, so that's an option for cases to come to that court, and then I would be the prosecutor handling those. We try and follow the best practices, continuing to stay up with what the best practices are in the country on how to deal with domestic violence and what we can do, and then training of our law enforcement and our community, which you're part of that outreach. So and training law enforcement is crucial because they're the first responders, the first contact the victim has, you know, with the criminal justice system. And we want to make sure that they are, you know, doing everything that they should to make sure that the victim is safe. And, you know, that's also important to Prosecutor Walsh. So that's why there are certain prosecutors who handle domestic violence cases in the domestic violence unit. Next slide. I want to talk, okay, I'm good on time. It's 7:15, right? Yep. Okay. So I'm going to talk to just a little bit about protection orders and the two different kinds of protection orders. So we have the anti-stalking order, and that would apply for non-intimate partner stalkers. So let's say someone decides they're fascinated with the clerk at Giant Eagle or whatever store, and they, you know, go to their home, follow them to their home, or they're leaving on their car. That's kind of what we're looking at as far as the anti-stalking order. And one would get that order through the domestic relations court. And then the other is a civil protection order, and that can be up to 5-year order where the protected party, as we call it, or I like to say the victim, just because it's kind of the lingo I use. So the victim goes in, tells the magistrate about violence and why they're afraid, and that they're in imminent fear, and then they get that 5-year protection order, and or however many years the magistrate grants it for, and then the anytime that offender then would have contact with the protected party or the victim, they could be arrested and charged with a crime. And those are enhanceable as well. They can be, your first one is a misdemeanor and your second one is a felony. Next slide. Okay, so questions about any of the domestic violence information that I gave you, or any comments about domestic violence, or anything that you think that, anything.
I think
Right.
Brenda-
Hello, Angie. Oh,
No, go ahead, Brenda. I was pointing, yeah.
oh, okay. My name is Brenda Justice. I have a ministry, Power Dream, Sisters Helping Sisters. We're advocates against domestic violence, and we just had a domestic violence workshop on specializing in strangulation because of all the legislation things they're going through with Ohio and so forth. And one of the things that they had mentioned, one of the probation officers from municipal court, there's going to be an app for protection order. Do you know much about that? Did you hear anything? Are you familiar?
No, an app.
It's supposed to be an app,
Really?
you know. Yeah, that's what he was telling us, and within the next 30 days or so, it's supposed to be in place. And so as long as you start that app, then you have some kind of protection, even if you don't finish it.
I'm gonna have to look that up.
Yeah, the probation officer, I'm just gonna let you, it was Tony Ingram in a municipal court.
Oh yeah, I know Tony.
Tony,
I'm gonna have to
Yes.
reach out to him.
yes, yeah. So we had a very good workshop. Thank you very much for all the information that you shared. I'm totally on it. So thank you.
And thank you for what you do.
You're welcome. 13 years.
Heart for the
Kathy-
work, right?
I'm sorry. Kathy had and I apologize. I didn't mean to cut you off. Were you guys good?
Go ahead.
Okay. Kathy had a question in the chat box, but Kathy, I apologize. I'll read it, but I'm not sure I understand the question.
I could just say, do you
Okay.
make referrals, and where do you refer to if you have somebody that's kind of iffy and doesn't fit your program, but you want to, have more time to talk to somebody, get a safety plan? Where do you refer to, or do you have contracts with agencies, or what do you do, or do you make it mandatory, or how does that work?
Do you mean for the victim or the offender?
Yeah. Well, maybe they'll go into marital therapy. I don't know, but initially, just to keep somebody wrap their head around the situations with more time.
One thing that we do as part of, let's say we have a victim who wants to drop the protection order while the case is pending. One thing that at least Judge Michael requires is that the victim attend what is called Stop the Cycle class. And that's where, that's through the Battered Women's Shelter. So we refer them to the Battered Women's Shelter for that class, for that Stop the Cycle class. And as part of that class, the victim then learns what we just discussed. They learn about the power and control wheel. They learn about the cycle of violence. They learn about victim blaming or minimizing. So they start to see for themselves, hopefully, the pattern of the relationship they're in and how lethal it could be. So that's one aspect of referrals that we have for victims. The other is, I always, anytime I have a Zoom meeting with a victim or an in-person meeting with the victim, I have at least one, sometimes two victims advocates. So one advocate from our office, one advocate from Better Women's Shelter. And we then, we had, a situation where the victim was an alcoholic, probably 10 years alcoholic, and had lost everything. And now he's beating her, and now he's in jail, and his mother's trying to evict her. And she was just really, really hit rock bottom, really. And the advocates are able then, because I have to remain neutral, and I try and, I'm sympathetic, but I try not to be overly emotional. But the advocates can do that. So they can then say, to the victim, here's the referral for treatment, for substance abuse treatment. Here's an idea of where you could go to for treatment for your alcoholism, or if you're drug addicted, or if you have mental health. And so we have all of those resources as part of kind of our team approach that we make sure that the victims have while they're on the phone with us, or while they're on the computer with us. We want to make sure that we get that information in their hand. And then one important piece, and I did it because I only have an hour, I didn't include it, but children. Almost all of these situations, there are kids that are seeing this, and kids who see this and experience this are going to be the kids who perpetrate tomorrow. So what we want to make sure we do as part of that meeting with victim is to give them resources for their kids. Especially with the body cams now, I see, 2-year-olds, 4-year-olds, little boys, little girls sitting there while dad's screaming at mom's bleeding, and officers are there. And so I'll say to the victim, I noticed that your son was really upset by this. Maybe you should consider child guidance, or some of the, children's counseling services that we have in the area for them, to try and help them through it, because it's definitely traumatic. So this also answers Tim's question about collaboration. So we make sure that we have all the information of all the different agencies, because not everyone likes Porter's Path. Not everyone likes child guidance. Not everyone wants to go to Summit Psych. So we want to make sure that we have a lot of information so that we can give them options. And, but one thing that I do prefer is that when we're talking about anger management, that it's not anger management, that they are, if they're a domestic violence offender, that they are going to a batter's intervention class, because anger management is completely different. You know, you could be angry and not be able to, you know, you scream at work, or you throw stuff when you get mad. You may have, you know, some anger issues, but when you physically hurt your family members, you need something more intensive than someone who maybe just has a road rage incident. So I'm definitely a stickler for batter's intervention. It's got to be either a 26-week program or a 52-week program, depending on their risk, the risk, and the lethality. So yeah, we definitely want to make sure that they are getting the counseling, and the advocates provide that information to the victims. And then if it's an offender, the probation department would provide that. In the probation department, they have, you know, a lot of resources to give offenders who are serious about treatment. And if there's one complaint I have, it's that we do not have enough inpatient health facilities in the area. And that's something that, because there are some offenders who have severe mental illness as well as domestic violence tendencies. And so we're battling two demons there, and you want to make sure that you're protecting the community. So you could send them to prison, but they're severely mentally ill and they're in need of treatment, but they're not stable enough to just say, go home and come in for treatment. So there are a lot of people who are being sent to prison simply because we do not have a lot of options for lockdown mental health facilities in any of the counties, really. So that's definitely a piece that if I had if I had $1 billion, that would be a really good investment, is a facility to help people who are severely mentally ill and try and divert them from prison. Although prison does offer a lot of resources for offenders. We, as part of one of our in-services, we took a tour of one of the prisons, and then I had been to a prison as a defense attorney too, and kind of got an idea of what was offered. And the people who are staying in prison for a long time, people who are there for a short time, don't really get a lot of treatment in prison. Some of the people who are there for an extended stay, they have options for mental health treatment and job skills, and different types of one of the programs they had is where they were taking dogs and training dogs to be service dogs. And so the inmates actually had their animal in their dorm, and they would be out in the yard with them, and it was and they also, as part of it, I think, had a screen printing shop where they taught them how to, skills, life skills not like necessarily life skills, but taught them a skill that they could use when they get out to make a living. So, there's some options there, but I'm not sure where it's at now as far as COVID and everything changed. But I know when we went, we were all surprised at how much James, were you with us? Were you surprised?
Yeah, we went to Grafton.
All of the options, all the options they had.
Yeah, and it was for people who had been incarcerated for a long period of time, who had done some pretty bad things, but in prison they, I guess, for lack of a better term, were able to turn things around and have positive experiences, and were provided these options. Grafton Correctional Facility does it, and it was very interesting, and it was a very unique experience, I guess is the best way to say. So Brenda, I saw you were going to ask a question too.
Yes, I was making very quickly. In the prison, is there anything, I know that you were speaking about different ways of helping them out, but is there anything that for people that is channeled, especially for those in domestic, that are domestic abusers, why you do what you do, you know, like almost like a AA type of situation. You know, do you know what I mean? I mean, like, because we're doing something with the with the males right now. And I just wonder when you're in there, is there anything that really focuses exactly on domestic violence?
I believe that they do offer the batter's classes within the institutions for the extended stays. Yeah.
Is there probably is a
They have
lot?
it.
I know there is a couple of people we know they're in there, but it seemed like they've been there for a little while, but it might be a long waiting list too, probably.
There is.
Yeah.
So if you're in there, what I heard at the last time that we were discussing it is that if you're in there for 2 years or less,
Hmm.
then you may not get, the programming. But I think the batter's intervention, I don't know if they even offer. They used to offer some of the classes in the jail. So like the alcohol classes and substance abuse classes, but I'm not sure if they're still doing that or not. But any treatment that you can get while you're in there is good. But one other piece is I think that is important, and we just discussed this as a team, is when people transition out of the institution into
Right.
the community, stepping them down into like a CBCF where they have the cognitive behavioral therapy. So they have the thinking for a change type of classes and distorted thinking and the batter's intervention. And so they have that programming that they didn't get in the institution. They get at CBCF before they're just released straight to the community. And that is for us kind of the ideal way to reintegrate some of the more violent offenders into the community.
Or
Since
are
we know them.
before they're released out into the community, are they do they go to halfway homes, or do we just release them and then go into the programs, or how does that work?
Some offenders just get released straight to the streets, and then others get be judicially released into CBCF or one of the inpatient facilities while they're transitioning out. And I think for us as a team, that seems like the best approach, unless you have an offender who has a lot of pro-social supports or programming in place and a lot of some coming out, then they may be able to get their own, treatment through their networks and not need the extra support. But there are a lot of people who really, really need that extra kind of the guardrails up when they
Yes,
come
exactly,
out,
exactly. Yes.
because it can be a hard transition. And yes,
Right.
I can share that lethality assessment. We can make everyone can copy of that.
Good.
So yes. Any other questions?
Yeah, Renee, there you are. Did
Yes.
you raised your hand? Did you want to?
Yes, I have a question or a comment or just
Okay.
a train of thought to share. I live in a senior building and I'm one of the youngest tenants here. And with domestic violence among seniors, I really hope we can get some legislation started to where if a police call is made for domestic violence in a senior building, they must do a drug test. And it needs to be part of the leasing, because they do have the form that we sign with our lease about crimes against women. But 99.9% of the domestic violence that goes on in these buildings is drug related. So at the time of arrest or within a certain period of time, they need to administer a drug test. Because by that time, the police have been called, some time that went by, they done cleaned up their act, everybody done got quiet, and nobody's talking, and they link hand in hand in these senior buildings.
Yeah,
I can see
I
that.
think Angie would agree that's a significant problem. And you talked about legislation, and Angie, I'm not sure if you were aware. There is something called House Bill 3, which is being labeled as Aisha's law.
Asia, or yeah.
Yeah, Aisha
Aisha's law.
Frazier,
Mhm.
she was murdered by her ex-husband 3 years ago. So it's called House Bill 3, passed the House today by I think it was, the number was 91-2, I think. I don't know who the two people who voted against it, but now it goes to the Ohio Senate and is going to be debated. This is the second time it's been passed by
Second
the Ohio
time.
House. And it got just basically just
Yep.
killed in the Senate. It just was set.
Yes,
So it's passed again.
Sad.
So we'll see if there are going to be any changes. Just reading briefly about it, there's some, not necessarily the drug test, that might be something that they add to it. But there potentially could be some changes to Ohio law when it comes to domestic violence. I see there's something in the chat. Oh, thanks, Darlene. Schools use cognitive behavior therapy too with some students too. Yeah, Angie, I mean, you've prosecuted bunches of different cases. Domestic violence cases are, unfortunately, some of the more difficult cases to prosecute, just for the wide variety of issues that come up between family dynamics, between, just they're so numerous. It's just not your everyday case. So, Angie and what we've got, how many, I guess, DV prosecutors in the office? The 4 who focus on that. Is that right, Angie? You and
Greg, Seema.
yeah. And we do trainings very often. So we're trying to keep it, as much information as we can possibly get. So it's 7:35. Thanks, Angie. I really appreciate your time and taking the time out of your evening. I don't want to cut anybody short. If anybody
you
has any
done
more
for the
questions.
night?
It ends at 7:30. We're actually, the past 2 times we've gone a little over. But
Okay.
if anybody has any questions, if they don't think of the questions now, please email Tanya or myself when you get a moment.
And
and
if,
we'd be happy to help.
ever any domestic violence related issues come up, my email and contact information is on the PowerPoint. And I think, do they get bios still?
I think so. I have to
Okay.
with there's Angie's email if you want to take a screenshot. These are recorded so we can send these out again. I'm not sure why Joe DeAngelis is on here. Joe is one of our supervisors as well in our office. It could be just that it's older.
We presented together one time,
Yeah.
so that's why he's still there. That needs taken off. But thank you so much.
Yep. And again,
One.
Angie, thanks. And again, if anybody has any questions really about anything, and you think about it before our next meeting, email us. We'll be happy to answer them. And if not, thanks again, everybody. Appreciate your time.
All right. Have a good
And
night.
we'll see you next
Bye.
Wednesday.
Thank you very much. Very good information. Take care.
Thank you.
Bye-bye.
Okay.